What happens if the opposing party doesn't respond to discovery in a divorce or child custody battle? Well, what can happen in Utah, where I practice family law, is covered by Rule 37, particularly Rule 37B of the Utah Rules of Civil Procedure. It provides that if a party is failing or refusing to respond to discovery, that you must first, before you can file a motion with the court, file a statement of discovery issues. The court then is to promptly decide the issues on the pleadings and papers, or conduct a hearing by telephone conference or other electronic communication, or order additional briefing and establish a briefing schedule before issuing an order. If the party who is the subject of the court's order still won't comply with discovery as ordered, then the court, upon motion, may impose appropriate sanctions for the failure to follow its orders, including the following: deeming the matter or any other designated facts to be established in accordance with the claim or defense of the party obtaining the order, prohibiting the disobedient party from supporting or opposing designated claims or defenses, or from introducing designated matters into evidence, staying further proceedings until the order is obeyed, dismissing all or part of the action, striking all or part of the pleadings, or rendering judgment by default on all or part of the action, ordering the party or the attorney to pay the reasonable costs, expenses, and attorney's fees caused by the failure, and treating the failure to obey an order as contempt of court. If a party fails to admit the genuineness of a document or the truth of a matter as requested under Rule 36, and if the party requesting the admissions proves the genuineness of the document or the truth of the matter, the party requesting the admissions may file a motion for an order requiring the other party to pay the reasonable costs, expenses, and attorney's fees incurred in making that proof. What usually happens, in my experience in family law, is that the party who wasn't cooperating in discovery waits for you to complain to the court through your statement of discovery issues, then in response typically gives excuses for failing or refusing to comply, such as a busy schedule, a crisis, real or fabricated, forgetting deadlines, or complaining that the discovery is unfairly burdensome. If your discovery is, in fact, unfairly burdensome, then the court, and although it's irritating, it's hard to blame the court most times, wags its finger at the non-compliant side, tells him or her to get it in gear, and gives the non-compliant side around 20 to 60 days, depending upon how demanding the discovery is, to provide you with a response or face the consequences. Can you get an award of attorney's fees for the opposing side's non-compliance? In theory, yes. In actual experience, usually not, unless the non-compliance is blatant.